Welcome to Property Management Law Solutions training module on how to prepare a 7-day notice to cure. First of all, property managers should be aware of their limitations as it relates to preparing any form or any notice on behalf of the property owner. The Florida Supreme Court has stated that property managers can prepare a 3-day notice to pay or vacate. However, they did not address the 7-day notice to cure or the 7-day notice to terminate. We will address that further in the training module. Be aware, however, that the Florida Supreme Court has approved forms, but the Florida Bar still gives a warning on their website regarding these forms, and that is the forms may or may not comport with current law, and that you should always seek legal advice when preparing notices in a landlord-tenant situation. The courts will construe notices strictly against the landlord. That is, if something is wrong with the notice and it does not comport to current law, that notice could be deemed legally defective. But strict construction rules are the highest kind of construction that a court can apply when interpreting language in a notice. So be very careful that notices are legally sufficient before you deliver them to a tenant, and also especially before filing an eviction based on that notice. Otherwise, if the court finds that the notice was legally defective using strict construction, then the court could in fact dismiss the eviction action. This training module does address curable violations. Curable violations are those violations that a tenant could cure, such as having unauthorized pets or guests, unauthorized parking, unclean or insanitary conditions, not maintaining the lawn properly, failing to pay a security deposit, and so on. If it is curable, the landlord must give the tenant an opportunity to cure before terminating the lease. In any notice to a tenant, it must have certain ingredients that are met. First of all, you must state all of the tenants' names on the notice. That would be any tenant who's stated as such in the lease agreement, or if it's a verbal tenancy agreement, then all of the persons who agreed with the landlord to be tenants at the property. Also, if there are any occupants in the property but they are not tenants, then you do not need to name those occupants on the notice. The same is true for guarantors, unless they sign the agreement as a tenant. In other words, occupants are merely occupants and not tenants. Guarantors are not tenants unless they've agreed to be a tenant in the lease agreement. If you have added or removed tenants during the tenancy, then you want to treat your notices accordingly. So if you've added tenants to the lease through, say, an addendum, then add those tenants to the notice. The same goes for tenants who are removed from the lease agreement. Do not name tenants who are removed. As always, you want to get anything that changes the lease agreement in writing, signed by the parties. You also want to name the property completely and fully in the notice. That would include the legal street number, name, a building number if there is one, or a unit number if there is one, city, state, and importantly, the county where the premises is located. The specificity requirement is essentially the what, when, to whom, and where of the incident. You want to make sure that you put each of those ingredients in the factual basis of the 7-day notice. You want to have dates, places, times, descriptions, persons, and names as best as you can is essentially a legal requirement that adequately informs the tenant of the nature of the evidence against that person so that they can effectively have a way of rebutting or defending the allegation if they intend to do so. One sentence summary notices are inadequate. An example: you have violated the lease by not keeping the property clean. That's not sufficient. You want to demand that the tenant cure. This is an example here of the language that is in a 7-day notice to cure prepared by an attorney. Demand is hereby made that you remedy the noncompliance within 7 days of receipt of this notice. You will also notice that this has a cure date in this language. There are courts that have ruled that the specific date of cure must be stated in the notice, even though the statute does not include the date to be cured. Courts have interpreted the statute that way. Conditional termination. That is essentially where you are saying if the tenant does not cure the default within the time period given, that the lease will be deemed terminated and they shall vacate the premises upon the termination. If you do not put termination language in the notice, then the court could rule that the notice effectively did not terminate the tenancy and that the tenant is still able to live there. So having termination language in the notice is very important to actually terminate the tenancy. Subsequent violations. This is where if the tenant commits the same or similar violation within 12 months of the first violation, that you can terminate that tenancy without having to give another notice to cure. But you must have this subsequent language in the notice to be able to terminate the tenancy if there is a second or subsequent violation. Of course, you must also have delivered the first 7-day notice to cure to be able to terminate on a second or subsequent violation. Keep in mind, courts have ruled if the first 7-day notice to cure was incorrect, that it may not allow the tenant to terminate with a second or subsequent violation notice. So that's why it's critically important that the first 7-day notice to cure be legally sufficient so that the second 7-day notice to terminate can also be legally sufficient. Regarding the attorney preparation of the notice issue, there is a court on point in Florida that says that since a 7-day notice to cure was not prepared by a lawyer, the 7-day notice to cure was defective, or in other words, the eviction could not be filed based on that notice to cure. And again, this goes back to the Supreme Court ruling that property managers can prepare 3-day notices to pay or vacate, but that is not addressed in the 7-day notice to cure situation. Effectively, it's practicing law without a license. So if you have a 7-day notice to cure to prepare, be sure to have your attorney look at it, help prepare it, and approve it before you do anything with the notice. The landlord can waive the right to evict based on a certain statute, 83.56, subsection 5A. It's where the landlord accepts rent knowing of the noncompliance or accepts performance of the tenant that it's at variation or variance with the rental agreement provisions. If that happens, then the tenant can argue that the landlord waived the right to be able to evict on the noncompliance that the landlord knew about but still accepted rent. However, there is an exception to that, and that is if the violation is continuing in nature or it's a subsequent violation.